In this section, we will address obstacles that self-represented litigants face in mediation. We will focus on identifying and understanding the most critical of these obstacles. Here are the learning objectives for this section. Understanding the kinds of obstacles that self-represented litigants face when in mediation. First, many do not understand the substantive law that underlie their claims, and they also don't understand how the legal process will unfold. Many don't have the negotiation experience necessary to fare well in the mediation. And finally, many have never mediated before, and therefore don't understand the mediation process.
Self-represented litigants face a whole host of other obstacles that impact a party's ability to participate in the mediation process, whether that party is represented or not. These other obstacles may include a biased assessment of the strengths or weaknesses of his or her case, overconfidence, or overcompetitiveness. In this section, we will focus more deeply on the particular obstacles that a self-represented litigant faces that may impact his or her ability to fully participate in the mediation process.
Lack of substantive legal knowledge.
One of the major obstacles a self-represented litigant faces is perhaps the lack of substantive legal knowledge. Self-represented litigants are often unaware of applicable legal standards and/or how to conduct legal research. A common situation a self-represented litigant faces is that they are completely unaware of the relevant provisions of the law, or they're only familiar enough to think that they are entitled to certain remedies without understanding the entirety of the statutory scheme or exceptions under which they may fall. Additionally, self-represented litigants may not know how to research the law or where to look to find that information. Self-represented litigants may misunderstand the law and what possible rights, remedies, and recourses are available to them. For example, a self-represented litigant knows someone who got a certain outcome in a similar situation. The self-represented litigant expects to get the exact same outcome without understanding the differences in the situations. Additionally, even individuals with good reading and writing vocabulary and competency may struggle with the legal vocabulary used in the context of a dispute. Words and terms sometimes have very technical meanings that are much more complex than what the self-represented litigant may mean when they use the word. In the landlord-tenant context, for example, I oftentimes hear tenants say that they are being discriminated against by the landlord. When some of them are probed further as to what they mean by that and why they think that they're being discriminated against, they sometimes simply say, "because she does not like me." However, discrimination under the law requires certain elements to be met before a case for discrimination can be made. Not liking someone on its own does not rise to the level of discrimination. Another example is the term statutes of limitations. Statutes of limitation is a technical term and can be triggered by different events in different contexts. So even if the self-represented litigant knows what a statute of limitations is, he or she may not be able to utilize it appropriately within the context in which he or she is operating. Self-represented litigants may conflate fair and legal to mean the same thing. For example, a self-represented litigant may think that it isn't fair and therefore must not be legal that they are being evicted from their apartment because they lost their job and cannot pay rent. Self-represented litigants may not know the range of possible outcomes if the dispute goes to court. Without considering all the possible ways a judge might rule on the case, a self-represented litigant may make an otherwise unwise settlement choice based on incomplete information.
A self-represented litigant's lack of substantive legal knowledge can negatively affect the outcome of the mediation in several possible ways. Three common ways that this can happen is the self-represented litigant could inaccurately assess the value of the case. They could have predetermined notions of what the law is and have that wrong and therefore think the case is stronger or maybe even weaker than they might otherwise believe. They can also make uninformed decisions. Simply being ignorant of the law, they don't know their legal rights. And finally, they could make unrealistic or unreasonable options as part of the mediation process that simply have no basis in the law. There are other possible reasons that the self-represented litigant could be affected by a substantive lack of legal knowledge, but these are the most common. Understanding of the legal system. Another common obstacle that self-represented litigants face is understanding the legal system. They may not understand the litigation process or how that system works. They may not understand how to prepare for mediation or the court hearing. For example, they don't know how long the process might take. They are often not familiar with evidentiary rules, the amount of time and effort that's required to defend or prosecute a legal action is often lost on self-represented litigants who have little experience with it, or discovery or the necessary pleadings often baffle them. Self-represented litigants may come to a session or a court proceeding unprepared. They may not have proper evidence, the documentation or paperwork, witnesses, and they may not have put a lot of thought into what they want from the proceeding. Self-represented litigants may also not understand the technical aspects of the legal system. They may miss court deadlines, file in improper venues, not serve process correctly. They may miss discovery deadlines. They may also not file or serve the proper discovery. This all affects the merits of their claim in mediation. As we know, lawsuits are not just judged by their substantive merits, but also their process merits. Lack of negotiation skill and experience. Self-represented litigants also face negotiation obstacles because many do not have the training or experience required to negotiate well. They may not have a good sense of how to assess the pros and cons of the merits of their case. They may not understand how to employ negotiation strategy that a more experienced person, certainly a lawyer or a business person, might. And that puts them at great disadvantage. Self-represented litigants are put at a great disadvantage in several ways with lack of negotiation skill and experience. For example, the lack of the ability to tailor concession making. Sometimes making concessions too quickly or too slow can affect the outcome of the case. Opening offers or responsive offers are sometimes too high or too low. Finally, sometimes self-represented litigants will come into the mediation room with one offer or one solution with little flexibility to change. This lack of negotiation skill and strategy will negatively impact their outcome. Lack of familiarity with mediation or experience mediating disputes. Another obstacle is the lack of familiarity with the mediation process itself. They may not have had any experience with the mediation, so therefore they may believe that the mediation process is like a court proceeding or an arbitration process. They may believe that the mediator is a decision maker when they're not. They may believe that the mediator is an advocate for them when they certainly aren't. And they may not realize that the mediation can be an empowering process. And they may believe that mediation is a useless process and will not achieve the end result when, in many instances, it's much more effective than an adjudication or an arbitration. Also, they're simply frequently nervous or fearful of a process that they know very little about. Possible lack of literacy or language proficiency. In many areas, there is a high immigrant population in which English is a second language. In these instances, the litigant may not understand what is being said or be able to communicate effectively without an interpreter or translator. Reading and writing is also important here to consider. The ability to read the contract, understand the contract, and sign something that you have understood completely is an important part of the process and often an obstacle for self-represented litigants who do not speak English fluently. There are, of course, many other obstacles that self-represented litigants face that we have not mentioned. Financial concerns, lack of education are among them. This section was meant simply to highlight for you the most common obstacles that self-represented litigants face in mediation. And as we go through this course, we're going to try to help you to understand how, as mediators, we can help self-represented litigants overcome these obstacles within our ethical boundaries.
You will now be directed to a short quiz to assess your understanding of the information just presented.